Good morning, Dr. Rama. I'm Fatin Maisara. The case I will be presenting is Nasraf bin Juan and Pendakwa Raya 2017, which is within the scope of Section 27 of the Evidence Act. From the facts of the case, the appellant was charged under Section 302 of the Penal Code for murdering his girlfriend. During the interrogation made by plaintiff witness 14, the appellant had killed the deceased using a knife and that he had thrown the knife in the bushes in front of the fire department building and led him and two members of K19. Plaintiff witness 14 claimed that the discovery of the knife was pursuant to the disclosure information under Section 27. The trial judge found that the prosecution had succeeded in proving its case against the appellant and a prima facie case had been made out as charged. The issue arose in this case was whether the disclosure information and discovery of the knife was admissible under Section 27 of the Evidence Act. Findings of the trial judge was the appellant was the last person with the deceased before she was brutally murdered by him, and he bore grudges against the deceased after he saw her with another man in town. The knife appellant was carrying was more than just a self-defense because he had carried it with him 3 to 4 days prior to the incident. The prosecution has proven its case beyond reasonable doubt against the respondent on the charge of murder under Section 302 of the Penal Code. The defense counsel submitted that the admission of the appellant to plaintiff witness 14 to be ambiguous and unreliable since his credibility was highly questionable. The defense counsel also submitted that the prosecution was weak and no prima facie case of murder was made out against the appellant. The appellant had set up a defense of grave and sudden provocation. The learned counsel prayed that the charge to be reduced and to a lesser offence under Section 304 of the Penal Code. The court in this case decided that the information given by the appellant does not come within the scope of Section 27. Thus, the trial judge refused to hold that the information, the knife he used in the incident, the knife that was used by him to stab the deceased, were inadmissible and should be expunged from the records. This statement also said to be in contravention with the case of Putrajaya 1947, where the information or statement challenge was "I stabbed with a spear. I hid the spear in my village. I will show you the place." The Privy Council had that the statement was inadmissible as it did relate distinctly to the fact thereby discovered. The court also stated that Section 27 and 8 are separate and distinct. Her ladyship had treated the appellant's conduct of pointing to the bushes where the knife was discovered by the appellant to plaintiff witness 14 was a continuous transaction, is confusing and misleading, and stated that pointing to the knife with no caution was admissible under Section 8 of the Evidence Act. This court stated that both provisions relating to admissibility of evidence, where the disclosure statement is governed by Section 28, whilst evidence of subsequent conduct is covered by Section 8 of the Evidence Act. If the disclosure information or statement is inadmissible under Section 27, the prosecution may pray in aid the evidence of subsequent conduct under Section 8. The court, in the view that the disclosure information in the case stand in the same footing as in the case of Putrajaya, thus it is inadmissible. However, the subsequent conduct of the appellant in leading plaintiff witness 14 to the front of the fire department, pointed to the bushes, thereafter retrieved the knife from the drain in the bushes, is admissible under Section 8. In conclusion, the court found that the conviction of the appellant was safe and affirmed the conviction for murder under Section 302 of the Penal Code. Section 27. There are few elements under Section 27 that we must take note. Firstly, information received from an accused person of any offence in the custody of a police officer. Secondly, from the information we will find the fact. Thirdly, this information will lead to a disclosure or discovery of facts. Next, the important word under this section is relates distinctly, which simply means if there is no information received or given by the accused, it is impossible or we could not find the tool used to kill the deceased or where the dead body is. In short, this information will lead to the discovery. Last but not least, it is important to take note that Section 27 operates as an exception to Section 24, 25, and 26. And information that relates to discovery also does not need voluntariness. That's all from me. Thank you.